So the first thing we're going to start with this evening is the Department of Ag and Markets have been busy writing letters. So I would like to read over two that I received the past week. So we have some copies that I only made 15 copies, so just have to share them. These will be posted on our website at some point, but there's copies on file with the town clerk as well. There will be. Supervisor Supervisor Reynolds Smith. And this one states, the department received a request from Brett Dixon, owner of Leo Dixon and Sons Inc., and Scott Wilkins, owner of Wilkins Dairy, to review the towns of Cameron, Thurston, Bath Solid Waste Management moratorium laws for compliance with Ag and Markets Law 305-A. Based upon information we received, it appears that the town of Cameron adopted its moratorium entitled Law Establishing Solid Waste Moratorium Facilities, 1-year moratorium on April 12th, the town of Thurston on February 21st, and the town of Bath on June 12th. In prior reviews, the New York State Department of Ag and Markets has recognized the authority of a town to place a moratorium on new uses and/or issuance of permits for a limited time so that the issue can be studied and code and zoning amendments can be adopted. New York State Department of Ag and Market staff are willing to work with the municipal governments in the drafting and reviewing of reasonable local laws to address agricultural uses in their community. The department has previously determined that a moratorium up to 12 months on space is not unreasonably restrictive. Some municipalities have adopted hardship provisions to offset the impacts of delayed reviews, which the department would support. However, our local government's administration of a moratorium by adopting lengthy extensions, stay moratorium, or the denial of a hardship request may be unreasonably restricted and in violation of Ag and Markets Law 305-A as applied to a farm operation located within a county adopted state certified ag district. Furthermore, the department has received Ag and Market 305 for review, the town of Thurston's local law number 3, a law regulating disposal of sewage sludge within the town. And then the department is reviewing that. They list on here, guidance you can find on the state website. And then this was CC to Brett Dixon, Scott Wilkins, Amy DeLugos, and then their Ag and Markets attorney. So it seems, we're within our right to have a moratorium. It's interesting. I don't quite understand why Wilkins Dairy filed a complaint when they're not permitted at this time to accept sewer sludge. And they're not even in the town of Thurston. It doesn't pertain to us. The second letter I received on October 3rd, last evening, it states, Dear Supervisor Molino, the department received a request from Brett Dixon, owner of Leo Dixon Sons Inc., to review the town of Thurston's proposed local law number 3. Ag and Markets, 305-A application states that the farm produces corn, soybeans, alfalfa, and the operation consists of 2,800 owned acres and 800 rented acres located in the towns of Thurston, Cameron, and Bath. Based upon information submitted, the farm operation and impacted farm fields are located within the town of Thurston. The purpose of an ag district is to encourage the development and improvement of agricultural land and the use of agricultural land for the protection of food and other agricultural products, which is set forth as a policy in New York State Constitution. Ag and Markets Law 305-A, one of the statutes that implements this state constitutional policy, states that local governments are prohibited from enacting and administering laws that would unreasonably restrict farm operations located within an agricultural district unless it can be shown that the public health or safety is threatened. The department performs reviews on a case-by-case basis, taking into account the specific facts of each situation prior to making a decision as to whether a local law unreasonably restricts a farm operation within an ag district. The department considers all information submitted by the affected farm operator, the provision of local law involved, and the comments from the affected municipality, among other pertinent information. Again, they give the site to visit, and then, of course, the town has 30 days to rebut this. So anyway, this letter, I mean, is premature given we have not enacted any law as of yet. And then I will just, general comments that I will make as it relates to both letters by Ag and Markets. First of all, we have the issue of sewage sludge. It is contaminated with toxic compounds as well as chemicals, other heavy metal chemicals. Class A, Class B, it's been proven it's there in low amounts. Testing, which is continuing. There's a second round of uncertified testing going on in Thurston. There is also certified testing going on in the town. And these tests have shown that there is PFAS contamination above EPA levels in the lands adjacent to the land spreading the operation in Thurston. Now, farmers have the right to farm. We're not stopping anyone from farming in Thurston, but all New Yorkers as well have the constitutional right to clean air, clean water in a healthy environment. And that is currently being infringed on in the town of Thurston. And it's our job as Thurston elected officials to protect our residents, not to protect farmers that reside outside the town of Thurston. It's not to protect big industries, billion-dollar industries. That's not our job as elected officials. And we received the feedback from the county planner. She disapproved our local law, and we have taken her comments into consideration. So that's all I have to say as it relates to these two letters. Does the board have anything to add? Okay. Okay. So with that, that's all I have on that. The next part of this is we have over the past, since our last regular meeting, we have retained Earth Justice, a nonprofit environmental law organization, and they have been reviewing local law number 3, and they have suggested amendments to strengthen it. And we this evening need to, if we continue to move forward, we need to accept these amendments. And it is, for me, they've added a lot to the legislative findings in the local law. And I have, copies that we will distribute. But I think, and they just finished working on it about 5 o'clock this evening. I forwarded it on to the board. I don't know if you've had a chance to look through it at all. We can go over, the basic thing is they have strengthened the findings. They've gone through and they, well, why don't I hand out we can hand out the draft of the local law, and then you all give me copies, take that. No, they removed that. That was, I sent that first, but then the final one they sent about 5:15.
I tried to download the video from before and it's going 45 minutes. But I download it over the
Wow.
So when you sent it, it didn't, I don't think include the attachment. The only thing I have is the original. I have the confidential.
That one, is this the same? I just sent it back real quick. I just removed that from.
Okay, so.
And they removed that, so it's.
Okay. Yeah, so it didn't, at least look like on mine it came through.
Okay.
But then it's hard to tell with the change.
Yeah, I know that I could have just. Okay, so the main, and then Rachel can add, the main differences is legislative items. They're within the text of the law. They are, much more substantial, and they're divided into different parts. There's a section on environmental rights, public health and safety, the proper disposal of the sewage sludge. Then there's the PFAS, a section on the PFAS threat, a section on, sewage sludge contaminating soil and water. And then that, the federal regulators recognize PFAS and sewage sludge that poses a threat to health and safety. Then there's, DEC regulation as it relates to sewage sludge and land application. Then there's a section specific findings from Thurston. And they've included an aerial map of Bonnie Hill. And then on page 7, you get into the purpose of it. And the main difference is this prior law, the way it was written, was a facility law. It prohibited any facility working within the town of Thurston. This prohibits the activity of sewage sludge spreading in the town. There are criteria that one would need to meet if they were to spread sewage sludge within the town of Thurston, and that's listed on page 9, the conditions that must be met. And I will give you, and they do talk about, New York, Thurston is a disadvantaged community. So anyway, you can read through the conditions, and then there's a section on penalties for the offenses and enforcement. The code enforcer has the authority to issue a stop work order on any sewage sludge spreading within the town of Thurston. And Rachel, you want to add anything to the main differences or the main additions to it?
Well, I think it might be helpful for people if you did read the prohibition section, so they.
Read the prohibition
section, the enforcement section, so that people are.
Right, it is more substantial than the previous law. So penalties for offenses at the bottom of page 9.
I would start with the before enforcement. Conditions on the land application of sewage sludge within the town, and then it said shall be prohibited, and then it has those. Section 6.
So conditions on the land application of sewage sludge within the town of Thurston. The land application of sewage sludge shall be prohibited within 10 miles of a disadvantaged community or within 1,000 feet of a potable well where PFAS contamination has been documented. In any place within the town other than those identified in subparagraphs A and B, unless an independent expert on PFAS and sewage sludge selected by the town board and paid for by the purpose proposing the land application of sewage sludge certifies A, that the land application will not cause any exceedance of an environmental protection agency health advisory level, environmental protection agency health base, water concentration, or agency of toxic substance and disease registry minimal risk level, and B, that the application complies with any applicable environmental protection agency rules, standards, or recommendations concerning allowable levels of PFAS in sewage sludge, and C, that the application will not cause any adverse effects to human health or the environment, and D, the expert shall grant or deny certification based on the submission of sufficient sampling data and other information by the person proposing the land application of sewage sludge. So, so that,
Yeah, I think it would be helpful to also read the enforcement section then, because that sort of gives a little more detail. As to, you know,
well, okay, the enforcement is much more detailed in the previous law. We can just, you know, like we said, with A, the town of Thurston shall issue a stop work order against any person in violation of this local law within 60 days of learning of the violation, if issuance of such a stop work order would prevent further violations of the said local law. Penalties provided for by this local law may be recovered in an action by the town of Thurston in any court of competent jurisdiction. The town of Thurston is also entitled to recover other relief, including an injunction, as the court may deem appropriate in such an action where the town of Thurston is the prevailing party. The town shall be entitled to recover reasonable attorney fees and costs, including expert witness fees and other litigation expenses. And I'll just read the section. The subsection, this will be posted on our website. The board decides to move forward. We will post this on our website. There will be copies of it on file with the town clerk. I'm not going to read through everything, but C, any town of Thurston resident shall also have the authority to enforce the provisions of this local law through an action brought to any court or a competent jurisdiction. So they could bring it to the town of Thurston board as well. And that's then on page, we'll go on 11. Well, then it breaks down the different. That's the. You're good.
It's worth pointing out that notwithstanding any preceding provisions, no action. This is D for the resident. This is under C.
Right.
To be initiated against the person alleged to be a violation if within 60 days of submitting the notice to Maine County or New York agency affirms in writing that the county or the state agency shall prevent further violations and ensure that the damage is remediated. And that the same is for the town. If the town is not going to bring an action, that the town, this is section 8B A. I thought there was that they have to So yeah, there's just some details here are good for everyone to understand how it works.
Well, this, we move forward, and we will need to have another public hearing. This will be put out there. The town has plenty of time to read through it, to understand it, and then we will. These are substantial changes. The law would have to be reintroduced this evening, and we would have to accept it. Move forward.
It's fundamentally a ban law. The same first language or the conditions have been modified.
Right. I understand I just got this to the board, but I don't know if you have thoughts. I mean, we can still, I mean, a board member can accept it, we can still, accept it in a draft form, and we can we'll still hold a public hearing on it and decide at a regular meeting what we want to do.
It is, but to accept something as form without reading through, do not feel comfortable.
Mhm.
I know they're working with free, but
Well, we can meet again, maybe next Wednesday.
So if you want, you need to, have an announcement 10 days in advance or
I'll call a special meeting and then 2 days notice, or, right,
for the hearing, for the wording of the hearing.
we would have to call a special meeting after if we decided to move forward with this, we would have to call a special meeting after our regular board meeting on the 18th. I personally think it's much improved over it, and then Noel has been in on, most of the calls with Justice and Gary Abraham and Rachel. I personally feel very comfortable with it. I think they've done a good job on,
Oh, yeah, that's the section I was looking for before. So, section 9, coordination with state law, which is, subsection D, that says, County of Thurston shall consult with, the Department of Public Health, Department of Environmental Conservation, and Spring County, no less than 30 days before enforcing this local law against the person. And so that there is that process that's been added for consulting with the state agencies and with Sudan County. So that process is required before going to court. But it's not required before issuing a stop order.
right.
So that's, I did want to point that section out.
Right.
Now, to do that. So.
It's up to, I realize you just, received it, we're not passing the final law this evening, but we've discussed this, I think, for almost a year, and clearly, it's a problem, and the majority of residents want something done, and I think it's our best.
which I'm not disputing. I mean, this is something I've been working on for 20
Yeah.
years, but to accept it as form means that you can only have limited ability to edit. So
Right.
if I find something in here after we've approved it as form that may allow them a loophole, so to speak,
Right.
my hands are tied and we're starting all over again. So that's why.
Right.
I mean, I think they've done a very good job and they've done it in a very short time, so, having, a little bit more time for everybody to experience serious, I think, you still have time possibly to consider it,
We still have our moratorium until February. Yeah. Well, we could call a special meeting in a few days, yeah. They would have taken as much time as I wanted. I did ask them to do this project. And they've been working on it quite a bit the past couple of weeks. Yeah. There's no cost to town for this. Right. That's fine. Yeah. So,
I don't think so.
that's fine, if you want, yeah? That's fine, yeah. Okay.
I kind of point out like was, the map, you mentioned the map.
The map of,
It's a very interesting fact there, that you might want to,
fine, yeah, we can.
just highlight that.
That's what we,
Want to read that, put that finding. It's the finding,
right.
which is,
On the next, on page 6, and then the finding is at the page of, bottom of page 5, WW, that according to the USDA Natural Resources Conservation Service Soil, Services Web Soil Survey, the USDA considers its single authoritative source of soil survey information, 95.5% of the land within a 7-mile radius of Bonnie Hill, town of Thurston, New York, is rated as having very limited stability for land application of municipal sewage sludge. So the area that is being proposed to land spread on is not even suitable for land spread on. So, right, so that's right. But anyway, the board can mark that another day, we can, you know, yeah, we can set it up to 2 days from, we can set it 2 days from now, if you want.
Have you been notified by DEC that they were supposed to have a public meeting? They should have a public meeting before you do any more on your road. In other words, for them to come out to explain to everyone to what's going on.
We met with DEC, they came to the Campbell Savona High School on August 10th. And,
Was that a public meeting?
it was public, it was open, they did want to meet in private with myself and the board, and I insisted that they come in public, and they did. There's a transcript of that on our website. Their argument at that meeting was that, passing a law like this violates, the right to farm law. However, we as a town believe that people's, their health and well-being is being infringed on, and that is not, that's not permitted. And spreading sewer sludge is not a normal farming practice.
Right, way different than.
Right.
Right. Did they also talk about medical? Because they have never done a medical test in here in New York, and they were working, I believe, with Cornell and everything else to find out medical waste and how it stays in, because there is no way that I have found out that you can take medical waste out of sludge.
Well, that's a good point, because they want to add the Bay Park wastewater treatment facility to the land spray permit. This is outside of JFK Airport in Long Island, and this wastewater treatment facility accepts wastewater from pharmaceutical companies as well as industrial users. And no, they don't have any way currently to filter that out. I've asked DEC for records as it pertains to the contamination of the sludge coming out of Bay Park. I asked for that in April, and we've seen nothing. So,
The talk that I had
Yeah.
with them back in the spring when I found out, they said that they would not okay the permit for the sludge till they had a final reading on the medical.
Okay.
And, how are they going to get it?
Right.
It's,
Yeah,
and then everything in New York
right,
with the amount of drugs and everything,
Right.
you don't have to have a medical
Right.
facility.
Right.
If you go in certain districts, you got
Right.
just dump it into the toilets.
And we in Thurston, we don't have a wastewater treatment facility. We don't have that. We don't have municipal sewer. So why do we need to accept other people's stuff? I don't know. you know.
There's another way of doing it, is like they, you know, the farmers around here, is to turn around and dry it. And then you turn around, you dry it, then you will heat it just like you do asphalt, and then it's dried. Then there wouldn't be any problem putting it on too.
Well,
But it costs money.
it costs money, and there's still a matter of the PFAS, they're forever chemicals, and they are still found in the dry stuff. So it's an issue. Big problem.
And I think the sewage sludge is actually defined to include dry stuff as well, the way it's defined.
Right.
Because a lot of places today, it's too dry.
Right.
But the liquid is what's the bad part.
And if the board wants to, you know, move forward with it tonight, I mean, one of you would have to, you know, make a motion to accept it, but if you don't, then we'll hold it, not call another meeting. In a few days.
I should go with it.
Well, I did have one question, as I'm reading through it, Rachel might be able to clarify, maybe I'm missing it, because I'm reading it rather quickly, but it says under the enforcement section, the town of Thurston shall issue a stop work order against any person in violation of this local law within 60 days of learning of the violation. What happens if it goes beyond 60 days? So let's say 62 days, I become aware that they've sprayed something maybe they weren't supposed to, or maybe testing hadn't been done, and we've learned about it. And 62 days pass because we don't have a code enforcement officer. Are our hands tied then, we can't do anything, or should we include provisions in there in the event that 2 days past our deadline go by? So enforcement under A, it says they have to within 60 days of learning of the violation.
Well, it's 60 days of learning of the violation, so
So it's code enforcement though, so if we don't have an active code enforcement officer, and we're relying, like the state said, they'd send somebody down, we're relying on somebody from the state, if we don't have a code enforcement officer, do we either give the town board the authority within the law that specifically says if no code enforcement is available?
Well, the way the law is written, though, I mean, even an individual could bring something.
Yeah,
against it.
residential. The stop work order.
Stop work order. Let me just double check the definitions. But I think the town is defined. Whenever this law refers to an action which is to be taken or authorized by the town, the provision shall be deemed to refer to the town board unless otherwise specified. So I think that is clarified there by the definition of the town. And it doesn't say
That it has to be.
Doesn't say it has to be.
Okay, that was my other concern, because we've had a difficulty filling that position.
Yeah.
Okay, so that was my other
Yeah.
concern. Because if we get somebody that's owned by the state and they don't want to issue it,
Yeah, I know.
we'll be
Right.
held to that, okay.
And I think it is good to make sure that everything works smoothly, you know. And understand these provisions because it is. It's 13 pages of provisions.
What's the criteria, Mike, so if you guys adopt this tonight, you can't change the wording at all, or you can do a minor change to it? I mean, where's the break off on that?
We could, my understanding, we could do minor wording change, but I don't really wanna do anything that could.
Exactly.
Right, that could, you know.
What my question is what defines,
When define, when is a substantial change? I mean, for instance, changing the whole. I still view, they've added a lot to it, but I still do view this as a substantial change, because overall the law, it's not stopping someone from having a sewage sludge facility in the town. They just can't spread it here. You see, the previous one stopped any type of facility. So that's kind of, but anyway, it just makes criteria for
Right, I was
spreading.
just
Yeah.
thinking along Holly's.
I mean, I think, yeah.
Along the line that Holly was thinking.
Right, I mean, I
If there's any
think,
changes.
right, I think those are minor changes, I do, but I think that,
The small, or the town, law, when you're passing a town law, I think like administrative changes, like wrong page numbers, minor clarifications, like clarifications of a point that's in there. But when you start changing things like penalties or, processes, then that constitutes probably a fundamental change.
So that would reset the whole.
So, but minor changes, like in the past, clarifications of, something that may be kind of ambiguous, we're allowed to go through. So, I mean, as long as you're not fundamentally changing a process, which was what some of my concern was with our first run through with this was, do we have a process to follow if we need to use it? So that's what I was looking at that.
You intend to send this back to the town?
What's that?
we do not need to send it back to the county planner. No.
You intend to send it back?
We will send it back to her, but we do not have to give her 30 days again. We will set the deadline.
Send it to her.
Right, we will send it, but she would have until October 18th to make those comments, to make informal comments.
And is there going to be a public meeting?
There would be a public hearing prior to our board meeting on October 18th, yes.
And so nothing else about the procedure that EAF is changing?
We were working on those forms, but those don't need to be, those are still the draft forms until we submit, till we pass the law in its final form. Right, before we pass it, but then we have the final form of procedure. Right.
So those won't be available for the public meeting?
That would, for the public at the public meeting, they would be, at that point, they would be available. And we'd have to leave at that point.
You're going to have a public meeting, no time to review.
You're gonna have 2 weeks to review this law. Right. You have 2 weeks.
Under secret act.
I mean, we can release part 1 and 2. I mean, that's, yeah, I mean, that's totally fine.
Just curious, you don't have to do anything.
Oh, I don't know about transparency, Larry. So, what do I do?
I know nothing about where I was going.
Okay.
I'm on blindsided.
No, I don't to be, on board, so, hope not.
Well, I mean, you've got a team of lawyers and you've got Rachel looking at it as far as the technical legal aspect of it. My consideration was looking specifically at enforcement and procedural. And I've had a chance to review those, and I don't see fundamentally, she answered the question I had, which was about that stop work order. I mean, I would be okay accepting it as form, and then, minor changes, obviously, could be
Okay.
through.
So just, I'll make a motion to accept it. Wants to take the time, go with it. I'm ready to roll. Okay. Okay, well, so first, now, just Rachel, to be clear, the resolution, I should go through that first before we accept this?
Yes, that's a resolution.
All right.
Accept.
Okay, so I will read through, now, I do have that resolution here. The first thing before, if we're gonna accept it, we just have to first, do we want to set the public hearing prior to our October 18th board meeting?
Well, in the resolution, it actually.
Yeah, put it in there, I'll just put it, you want it, yeah, okay, I'll say it in the resolution, then, that's fine. All right, so I'll read through the resolution, this will be the resolution to accept this as form. So the resolution is dated Wednesday, October 4th, 2023. It's the resolution of the town of Thurston Town Board introducing amendments to proposed local law number 3 of 2023, a local law regulating the disposal of sewage sludge. So these are the whereas statements. So the first one, whereas this resolution introduces amendments prepared in consultation with nonprofit environmental law organization Earth Justice to the proposed local law introduced on August 16, 2023. When adopted, this law will regulate the disposal of sewage sludge in the town of Thurston. 2, the local law is proposed pursuant to the authority and power granted to the town board and the town by the New York State Constitution, Article 1, Section 19, and Article 9, Section 2C, Section 10 of the New York State Municipal Home Rule Law, Section 130 of the New York State Town Law, Section 10 of the New York State Statute of Local Governments, and Section 27-0711 of the New York State Environmental Conservation Law. 3, the purpose of the local law proposed in this resolution is to close gaps in existing state and local laws, regulations, and ordinance governing sewage sludge disposal in the town of Thurston, so that persons in the town may realize their fundamental rights to clean air, clean water, and a healthful environment, and to ensure that the health and safety of residents of the town of Thurston are protected, taking into account the unique features of the town, including the topography, and the vulnerability of persons who live, work, and recreate in the town. In anticipation of the introduction of the local law, we directed Rachel Treichler, the town's attorney, to prepare for the town board's review a full environmental assessment form, FEAF, Part 1 and Part 2, pursuant to the New York State Environmental Quality Act, (SECRA), which she presented to us before a meeting on August 16, 2023. Ms. Streichler has prepared revisions to the FEAF Part 1 and Part 2 presented to the town board on August 16, 2023, and present the amended forms to the town board for review and consideration tonight. And I will make sure town clerk will have those on file tomorrow. And then 5, at our meeting on August 16, 2023, the town board determined to classify the adoption of the proposed local law as a Type 1 action under SECRA. The town board further determined that it will be the only agency with approval authority over the proposed action. Accordingly, the town board declared itself to be lead agency for the conduct of the environmental review of the proposed action under SECRA. The town board further identified the Steuben County Planning Department as an interested agency. 6, prior to our meeting on August 16, 2023, we directed Ms. Streichler to prepare a list of references supporting the legislative findings contained in the proposed law. The references prepared by Ms. Streichler and presented to the board on August 16, 2023 have been revised and supplemented in consultation with Earth Justice. The town has received the Steuben County Planner's reply to the town dated September 15, 2023, recommending disapproval of the original version of the proposed local law number 3 of 2023 and has considered the county planner's comments. 6, pursuant to the New York State Municipal Home Rule Law, Section 20, amended local law number 3 of 2023, the local law regulating the disposal of sewage sludge and the accompanying amended references were received by each member of the town board prior to this meeting via email, and proposed local law shall be deemed to be on the desk of each member of the town board as of tonight's board meeting. Now, therefore, be it resolved, Section A, for the reasons set forth in this resolution and pursuant to New York State Municipal Home Rule Law, Section 20, the town board hereby introduces revisions to the town's local law number 3 of 2023, a local law regulating the disposal of sewage sludge. And a copy of the revised proposed local law number 3 of 2023 is attached as Exhibit A to this resolution. The town, Section B, the town board hereby accepts the revised supplemental list of references for the revised proposed local law. A copy of the revised list of references is attached as Exhibit B to this resolution. Section C, the town board hereby accepts the revised SECRA FEAF Part 1 and Part 2 for the proposed action that have been prepared by the town's attorney, Rachel Treichler. A copy of the revised SECRA FEAF Part 1 and Part 2 are attached as Exhibit C to this resolution. Section D, the town board hereby directs Attorney Gary Abraham to send the proposed revisions of local law number 3 of 2023 and the revised SECRA FEAF Part 1 and Part 2 to the Steuben County Planning Department for its informal comments pursuant to Section 239-1(3) of the New York State Municipal Home Rule Law. Section C, in accordance with the New York State Municipal Home Rule Law, Section 25, The town board hereby schedules a public hearing on the revised proposed local law for the board's next regular meeting on August 18th, 2023 at 6:30 PM to be held at the Thurston Town Hall located at 757820 Route 333, Cantville, New York, 14821. The town board directs the town clerk to provide notice to the public of the public hearings in accordance with the requirements for same set forth in New York State Municipal Home Rule Law, and direct the town clerk to for the publication. And the town's official newspaper, no less than 10 calendar days prior to the public hearing. And then the town board also directs the town clerk to post a copy of the proposed local law on the town's website, and to make paper copies of the proposed local law available for review by the public at the town of Thurston Town Hall located at 7578 County Route 333, Campbell, New York, 14821.
You went the same October.
Oh, yeah, sorry, October 18th. All right, yeah. Okay. So, do I get?
Can I make one comment?
Yeah.
Will it mess up your flow of things?
No, no.
Under, on page 9,
Mm-hmm.
under the penalties and offenses,
No.
it talks about if anybody violates the law,
Mm-hmm.
they're liable for the removal of the solid waste that violates it, and they're also liable for the restoration of land.
Mm-hmm.
But there's no, it doesn't say who, how do you enforce that part of it? I mean, who's gonna actually do the removal and restoration, and who's gonna oversee that?
Well, this would be pursuant to the court proceeding, and so these are penalties that the court can award. And I mean, ultimately, the court would make the decision as to,
Remediation.
so,
Right. Oh, yeah.
you know, it would be, yeah, you know, presumably the violator would say, this is what they would do, and if the town rejected, they could say that's not sufficient, and the court would. And probably it would be a process where, you know, the violator says, okay, we're doing this, and the court would have continuing oversight to make sure that it was done. But that's frequently with different types of penalties, the court has oversight to see that it's done properly, but these are penalties that will be imposed by the court. And it does have, the final section there that, you know, how that town should spend the funds if there's additional needs. So, and there's D is for the cost of filtration of drinking water contaminated as a result. And then there's additional monetary penalties. So.
Another question? All right, so can I get a motion to accept the resolution? Who makes the motion? Second, and seconds it, and we're gonna get a roll call vote.
Molly? Yes. Dan?
Yes.
Michael?
Yes.
No.
Yes.
Sounds good. Just so we have more time to review it, and I think it's important enough that we should review it. You guys don't really necessarily need me at this.
You're gonna
time.
abstain if you don't wanna say no. Abstain.
I prefer to say no, just because I haven't had enough time to
Okay.
review it.
Okay. The motion is carried 4-1. That's, yeah, and will be posted on the town website, and there will be hard copies of it as well on the town clerk, and the secret documents will also be available with her. So public hearing will be August 18th at, excuse me, yeah, I keep thinking about it. Yeah, it'll be October 18th at 6:30. So. And that concludes, can I get a motion to adjourn the special meeting? I makes a motion. All seconds it, all in favor? Aye. Okay, so next we're going to be, that concludes that, we're holding a budget workshop now. You're welcome to stay if you like.